Ready? Yeah. So the question
Sorry,
is...
Brad, I'll just introduce first. So this is John Milburn for Laws 12060 Trusts, and we're into week 6. This week, the topic is duties, powers and rights of trustees. Now, Brad, you've joined us. You've got a question.
Okay. I have a client that lives in Thailand, an Australian citizen. His assets are in Australia. He's married to a Thai lady, has been for some time, quite a while. He's of ill health, so he's doing a new will, powers of attorney, etc. So the administration of that estate would be where? If he is resident and so he's a citizen of Australia but non-taxpayer because he doesn't spend enough days here. He's resident in Thailand. So the question is, to make it about trusts, if the assets were held in a trust in Australia, we could administer it here. But if they're not held in a trust, where would be the domicile for probate?
Wow, that's a tricky question. It is possible to obtain probate in both jurisdictions or to seek what we call an exemplification of probate, which means that you take probate in one jurisdiction and have it registered, if you like, in the other jurisdiction. So, but generally speaking, the issue is determined in the jurisdiction where the assets are located. So it may well be that it's a dual administration. So okay. I'm sorry, it's not my specific area of practice, but that's what I believe to be the answer.
But if the client holds them in trust, we could administer the trust assets here in Australia. So yes. If he had a share as a trustee of a trust, held the assets in trust, he could then bequeath his shares in the trust to the designated beneficiaries.
Yes.
And then they could deal with that trust. Okay.
Yes. That's my view. Now, yeah. Did you do some research on that? Was there something other than what I've said?
Yeah, there was some certain case law, Lee's succession law that my the managing partner handed me. I said, well, it doesn't deal within that text. I looked in my text, didn't have it there. Went on to Halsbury, and the directions there were essentially look at international law arrangements. There's a convention, but I couldn't find who all the signatories were to the convention of that in regards to succession. And it generally dealt with, so in Thailand, you deal with any Thai law, but that's only of Thai citizens. Yeah, so it was rather complex.
It is a bit complex. All right, we probably better leave it at that, and we'll move on to tonight's topic. But the other place I'd look is De Groot's publication. Excellent on wills and estates. But yeah, Lee, Halsbury, Groot's, they're all very good. Okay, so last week we talked about trustees, what it means to be a trustee, how a trustee is appointed. This week we look at the trustees' duties and their powers and their rights. So the reading was from chapter 26. Hopefully you're finding the reading a little easier as we progress. I know it can be difficult, and I know that I haven't been posting answers on Moodle to the weekly problems, but there is a bit of method in my madness for not doing that. I really want people to actually commit to an answer. But we'll see. Hopefully we'll have some time to talk about the weekly problems tonight. Now, before we start, are there any questions, comments? And I say that because I will answer a question that Brad asked just before we started to record, and that is, where do we keep these Zoom videos? And the answer is that generally I'll let you know when I've uploaded, but I usually upload onto Moodle on the night or the next day after the recording, and you'll find them in latest news, which they'll stay for a week, but you'll also find them in the weekly session. So if you look under week 4 Moodle, you'll see the reading, you'll see the materials, you'll see the problems, but you'll also see the recording that applied for week 4. So each week I'll add the recording into Moodle in that location. So hopefully you can find it. Other than that, any questions? Comments? Question from Sophie. Can you explain exoneration? Any thoughts on exoneration? To exonerate, what does that mean? Yeah, was that an answer? Someone coming through? All right, to exonerate means to forgive, I guess. Sorry, Erin?
Yeah, to excuse. I
Yes.
said to excuse.
Erin says excuse. That's right. I would say excuse, to forgive, to permit retrospectively. So it has that element of after the event, allowing something that perhaps shouldn't have occurred to occur with your good grace, would be probably my best guess. So if you're in terms of what exoneration is, hope that answers the question. Okay, so I'm going to pose some questions for you. First question is, what's the difference between a trustee's duty and a trustee's power? You might think that's a pretty obvious question, but it's a bit of a loaded question. What's the difference between trustee's duty and power?
I guess the duties are fiduciary duties, whereas the power, they derive that from the trust deed itself, and if there's nothing in the trust deed and there's any disputes, the courts can determine as well.
Yes, I'd be interested for other thoughts on that, but fiduciary duties and trust duties cross over considerably, but they are technically different from each other, but they have many common elements. Sophie says a power is a right and a duty is an obligation. Yep, I think that's probably right too. But sometimes, and this is the point of asking that question, sometimes we find that the two are very closely aligned. And if someone has a power as a trustee, the courts will often take that to mean they have a corresponding duty that goes with it. So where do we look first to find the law on that subject? If I said to you, explain the difference between a trustee's duty and a trustee's power and give authority for that, what's the first place you look? And Brad's right, he's got the answer I'm looking for. And it's something I'm trying to drill into. Oh, yes, you're all saying it now. You have a look in the Trusts Act. We look at the legislation first. My view is we don't look at the textbook first. We don't look at the case law first. We don't look at other commentaries. And we don't send off an email to someone saying, what's the answer? We look at the legislation. All right? So we've got that one. So we look at the Trusts Act. And the Trusts Act is not in Queensland a code. We talked about that. So a code is where there's an attempt by Parliament to put everything that relates to the area of practice into the one piece of legislation. So bearing in mind that the Trusts Act is not a code, we have to be mindful of the common law and apply the common law, but we do look at the code first. So in general terms, a trustee's duties are to comply with what first? Now, it's a trick question. So I said the first place we look for the law is the Trusts Act, but where's the first place we look to determine the extent of the trustee's duties and obligations? Trustees Responsibilities Act? No. Or like Erin's answer. Erin's come in with the answer I'm looking for. We look at the deed, the trust deed. Vivian said the same thing. The instrument, says Linda, so the same thing. So when we're trying to determine the law, look at the legislation. When we're trying to look at the extent to which a trustee is obliged to do something or has power to do something, first have a look at the instrument, or the trust deed it will normally be. What's the difference between a deed and a contract? Can anyone tell me that, just to digress for a moment? Deed and contract. Difference?
You're on mute, John.
Oh, I'm on mute, sorry. So the answers we were getting, I think, are all right. People are identifying the difference between contract and deed as consideration. So they might look the same. When I first started practicing law in the 70s, we used to actually affix a seal to a deed. So we would have literally some wax. We would burn the wax onto the document. We'd have a seal, like, you know, medieval times, and we'd affix the seal and we'd impress it into the wax. It was all very impressive sort of stuff. But that was the physical difference between. You won't see that anymore, but a deed, there's no consideration. And most trust documents, most trust instruments, are created by way of a deed rather than some form of contract. Okay, so we know that we need to look at the Trusts Act for the law. We need to look at the trust instrument, let's say a trust deed, for the sake of what it normally is. In terms of identifying the power to invest money, where would we look in the Trusts Act to find that out? And it's a good idea to have the Trusts Act open on your screen tonight. So where do we go in the Trusts Act? Are we finding it yet? I'm just going to mute your microphone, B. Linda says section 21. I like it. But it's a bit broader than that. That is exactly the power of trustees to invest. But it's broader in the sense that it's all of part 3. So to remember we said, I think we said this last time, when you're looking at legislation, what I like to do is have a look at the document as a whole first, sort of flick through it. Then you go back to the index and look at the parts and the chapters and the divisions and get a feel for it, and then look at the sections and have a look at where the section fits in within the part or the chapter or the division, as the case may be. So section 21 is exactly the right answer. That's where the power to invest is hidden, but you'll see that it's part of part 3, which deals with investments generally, and that's sections 20 through to 30C. So the important part about the power to invest is that it says a trustee may, and that's where we have that discretionary aspect that was the difference identified between a power and a duty, but a trustee may, unless it's expressly forbidden by the trust instrument, invest trust funds in any form of investment and, so there's an and, at any time vary that investment and realise an investment. So when you're looking at legislation, I'd urge you to identify keywords and then think about those words. So we're going to do that a bit now. But remember this part, and this is why I want you to make sure you look at the part generally. Remember that the duty contained in section 21 is subject to sections 29 to 30C that apply despite anything that's contained in the trust instrument. 29 is the power to retain investments. 30 is about loans and investments by trustees, not in breach of trust in some circumstances. 30A deals with limitation of liability of trustee for loss on improper investments. 30B gives the court power to take into account investment strategy in action for a breach of trust. And 30C gives the power to the court to set off gains and losses arising from investment. So coming back to that first point, when you look at section 21, that's fine, but look at it within the context of the part, because in this instance, we've got a really good example of how other sections within the part can have an effect on the section that you're looking at. And if you just look at the one section, you might miss something really important in terms of how that section is to be construed by a court in practice. And Erin said section 6 as well. Okay, so section 21 applies in terms of investments. 22 is really important because it applies to trustees generally, and it's a duty of care, but we call it a statutory duty of care. We do that because it's in a statute. Pretty obvious, I guess. So it's a statutory duty of care. And section 22 says that trustees generally must exercise the duty in a certain way. If it's a professional trustee, a trustee that does this for a living, the bar is raised higher. The courts expect something better from them than someone who is not. But it does say that subsection 2, but generally section 22 says that a trustee must do certain things when exercised in the power of investment, which they are given in section 21, and maybe the trustee as well. Subsection A of 22 says if you're in business, the standard of duty is exercising the care, diligence and skill of a prudent person engaged in that profession. Whereas if not, it's simply exercising care, diligence and skill of a prudent person of business. What section 22 says to me is, before you ever consider being a trustee, make sure that you understand you've got a lot of obligations here. And if you're a professional trustee, even more so. Now, I guess what I'm leading to is this. Sometimes people fail to act in investments, and sometimes people act, but they suffer a loss. Now, if a trustee suffers a loss, will they automatically be liable to their beneficiaries to the extent of that loss? Straw poll. What do you think? Yes or no?
No. No.
No. We're getting votes no and no. Anyone say yes? All right. I like the answer no. Won't automatically happen. What's the core duty? If we had to identify a core duty of a trustee, what would you say it is? Care and diligence. I like that. Yep. Look after the beneficiary. I like that. And if we tie those two concepts together, we're getting very close. Take care and diligence in looking after the beneficiary. That's pretty close. Gemma says act in the interest of the beneficiary or the trust. So that's really close as well. A couple of things I'd like to add to that as core duties. I like all of those things, particularly if you tie them together. You've got to act honestly and you've got to act in good faith in doing so. So if we had to identify the core duties of a trustee, I would say act honestly in good faith for the benefit of the beneficiaries in a way that a reasonable person in business would do so. Thank you for that rider, Brad. I like that. That's excellent. So that's tying in the core duty with section 22. So keep that in mind in everything that you're doing in your discussions about trusts law, particularly in the context of what a trustee has done. And if you apply that test, it's possible that the trustee has acted with care and diligence, looking after the beneficiary in the interests of the beneficiaries, honestly and in good faith, and yet still suffered a loss. That's possible. If you want to see some practical effect to this, I'm going to give you some cases. I'm not sure if I put them in the notes, but the first one is Breen and Williams. Breen and Williams was in 1996. It was 1996 HCA 57. And Justice Gummo said, when describing the obligations of a trustee, the trustee is required to both observe the terms of the trust, that's the first point, we look at the trust deed, and in doing so to exercise the same care as an ordinary prudent person of business would exercise in the conduct of that trust if it was their own. Now, let's go back to a point that I made earlier about section 21. Section 21 gives the trustee power to invest, and the trustee may invest. Great. But if we tie that in with what's in section 22 and what Justice Gummo said in Breen and Williams, I wonder if we could make an argument to say that the power which is conferred upon trustees in section 21 is in fact a duty. Now I'm going to put that as a proposition. Does anyone think that that is possibly the case? Doesn't say it, but could we make an argument? You can say no, you don't have to agree with me. Oh, and Brad says, yes, it's in week 7 notes. Did I put it in? Did I say it is? Act in the best interest of the beneficiaries, do so as a reasonable person in business. Yeah, look, I think so. And I think the reason why you have to almost assume that the trustee has a duty to invest in many circumstances, not just a power, but a duty, is ask yourself, would a person in business, a reasonable person in business, invest those funds? And the answer is probably yes. I mean, if it's only a very short period of time and the funds are not substantial, probably, maybe we could let it slide. Maybe we could exonerate the trustee in those circumstances, or the beneficiaries could. But let's say the trust that you were in care of, like the one that Brad was talking about, an estate matter, for example, and you had a substantial amount of money, whatever that might be. Let's say it's $500,000, and you had that sitting in your trust account as a solicitor for 12 months, and you didn't invest it. As a trustee, have you complied with your duty? Is it a defence to say, well, I have the power to invest, but it says may? I don't think you have. I don't think you've complied with your duty. All right, so most people would agree with that. So that's where I make that original statement that sometimes it may look like it's a power, but really it's a duty. So be careful about that. The other case that I want you to have a look at, and please tell me if I put this in the notes. I should have checked the notes beforehand, but it's ASIC, which is the Australian Securities and Investment Commission against Drake. And it might be further on in the notes. Brad said it's in week 7. So have a look in week 7. That's a really interesting case. Justice Edelman, I think this one will go on appeal. I've just got a feeling it's going to go on appeal. But Justice Edelman in the federal court, the citation for it is ASIC, ASIC against Drake, number 2, 2016, FCA 1552. It's a really good discussion about the way in which Justice Edelman considered the law regarding an alleged breach of trust. His Honour considered, the court considered the nature of the trustee's duty and care, and the court considered whether a trustee can exclude equitable obligations which are contained in Section 22 of the Queensland Act to act in a prudent manner. So it's a really good way of tying it in. Anyway, you may have read in broad terms what the case was about was this. ASIC said that directors breached their duties in a managed investment scheme. Ultimately, the court dismissed ASIC's case entirely and said, no, they've done nothing wrong. What happened is there was an investment made in a management trust. It was to do with property on the Gold Coast, like a managed fund on the Gold Coast. And this trust invested a very substantial amount of money, $142 million, into a single loan. It was about half the size of the total fund. And it was that loan that was made that was the subject of the proceedings. The investment was put into a real estate venture called Madison Estate. They set an interest rate at 25%. Anyway, things went badly, and ASIC said the directors breached their duty of care. They alleged that different questions arose in relation to other types of cases where there's an unauthorised act, but they said in this one there was a duty of care. Even though the act was authorised, that is, the act of lending the money was authorised, they still breached their duties. So make sure that you differentiate between where the trustees have acted with authority as opposed to where they breached their authority and done something which is unauthorised. So in that court, the court said that they had to consider whether the trustees can exclude or modify the duty which is referred to in Section 22. And they said the strongest factor in favour of ASIC's construction was that the legislation used the word must. So again, we're talking about that mandatory versus discretionary issue. So the court said that read in isolation, the word might appear to impose a duty and not contemplate the possibility of varying that trust by provision in the trust deed. However, the alternative possibility is that the word must created a mandatory default rule in those circumstances. Anyway, just to confuse issues, but I think that the decision is right, is that the court interpreted Section 22 as being a permissible power, even though the Act uses the word must. So what we can take from that is this, that even though there is an obligation on the trustee to act in a certain way under Section 22, that according to the principle in Drake, and this decision was only handed down just before Christmas, notwithstanding the use of the word must, the power may be exercised permissibly if the terms of the trustee allow that to occur. In other words, Section 22 does not prevent a clause, appropriately drafted of course, from excluding those fiduciary duties. And the court looked at Section 23 as specifically contemplating that possibility. So that's a little bit tricky. And I know that I've gone back to the starting point of saying this was a permissive use as opposed to a mandatory obligation, if you like. But read sections 21, 22 and 23. Remember the provisos in 29 through to 30C, but do that within the context of Justice Edelman's comments in Drake. Do that and we're fine. We're on top of it. Any questions arising from all of that before I move on? All good?
Just wondering, John.
Yes,
John,
ma'am.
can I just ask, why do you think that'll go on appeal? What's the issue that will be appealed?
Oh, I don't know. Just I just think it will. Intuition. That's all. And really, I think when you read these cases and when you look at a factual situation that's presented to you in practice, don't be afraid to think that there may be a counter argument to these things. I mean, I'm just amazed at the number of decisions that are overturned between, say, the federal court and the High Court, or the Supreme Court and the High Court, or the District Court and the Supreme Court, Court of Appeal. It just happens so often. What that tells me, there's always an argument in relation to these things, one way or the other. Anyway, no particular reason, Aaron, just that it's a gut feel. I might be wrong. We'll see. Yes, Brad?
Just to go back on what you said, did you say that Justice Edelman said that he was able to amend the deed to reduce the powers pursuant to 21? Is that?
No. Justice Edelman. Justice Edelman said that the way in which the deed was drafted could exclude the fiduciary duty in that instance. So the drafting was appropriately. Sorry, Brett.
Okay, so then in week 7's notes, the permanent trustee company in Dougal, it says that a clause that seeks so to limit the beneficiary's right to take proceedings will be void as an attempt to oust the court's jurisdiction. Yeah,
I think that's different because what we were saying in the Drake decision is that that's a modification, that's an exclusion of the fiduciary duty. It's not saying you can't come to court and argue the toss. So I think in the decision that you're talking about in week 7, there's an attempt to exclude people from going to court and getting their foot in the door to place their argument.
Okay, I just thought by putting in that clause it would limit their abilities, but anyway, yeah, I know, I see your point.
Okay. All right, so now I'm going to ask another question. Can anyone tell me what the rule in Howe and Dartmouth is? It's from 1803. It's been around for a long time. What's the rule in Howe and Dartmouth?
Was that the one where the court won't interfere with the trustee's decision unless it's really off track? That they don't have the right to review the reasons why unless the trustee has actually given those reasons?
Yeah, I think in probably even more generally than that, it's a rule that seeks to strike the balance between the interests of people that receive a life interest in a trust as against those who receive an interest by way of remainder. So if you've done succession law and you've done wills, you'll have a better idea of what I'm talking about here. But often you'll see trusts which are established which give people certain entitlements to income while they're alive and then state that upon their death, the balance, which is the capital, goes to the, to another person. We would call the remainderment. this is where Howe and Dartmouth comes in, because it basically says a trustee has an obligation to be fair to both. So, as far as the person who receives the capital is concerned, they may argue that the only sensible thing to do with that money is to lock it away and earn a term deposit, absolutely guaranteed capital. Doesn't matter if the term deposit only receives 0.5% per annum. The people that are interested in the income will say, no, we think that it's much better to invest in these tech stocks and IPOs, because we might get an income which is more like 20% per annum. Okay, it's a bit risky, you might lose your capital. So Howe and Dartmouth is basically a prescription to trustees to maintain a balance in those instances. Okay, so keep that one in mind. All right.
John,
yes,
John, is there an authority for that in Australia, a recent Australian case?
Not that I can cite, not that I can give you straight off the top, Erin, sorry. But it would be a good exercise. You know, there are the facilities in the websites where you can key in the information and see where that case has been applied. One that I like is Jade Barnett. I don't know, have you looked in Jade Barnett? Jade's really handy. You can do that through Ostley as well. But I normally go to Jade for that task. Okay. So we know that the trustees have an obligation to act honestly and in good faith for the benefit of the beneficiaries. We know that. That's pretty straightforward. We know that's a core duty. If you were a trustee, how would you go about establishing that you are in fact acting in good faith, honestly, for the benefit of beneficiaries, so that you minimise any successful attack on what you do?
You can actually
yes,
can actually gain professional advice. You can actually get professional advice.
That's exactly the answer I was looking for. You can seek out and obtain and act on investment strategies through professional advice. We had some other good answers come through. Linda said keep good records, absolutely. And Gemma said communication, that's always good too. But the answer I was really looking for was the ability to obtain proper advice. Now, what would be your justification for doing so? If you were challenged and a beneficiary said, you're wasting my money going and getting an investment plan drawn up, what would you say? We've already talked about it tonight.
Supposing you're not a professional trustee and that's not your area of specialty, you're not trained in that area.
Yeah. So one answer is you're not an expert. Maria says that, same as you, B. I like Brad's answer. Practically speaking, this is really important. Move the liability to the financial advisor. That's a really sensible idea. But in pure theory, I'm still looking for my answer. And I'll give you a hint. We've already talked about it tonight. The first place we look when we're looking for an answer is... Yes, Linda? First place we look when we're looking for an answer.
Yeah, it's our duty.
Yep, it's our duty.
Yeah, duty of trustee in relation to our investment.
Exactly. All right, so we keep coming back to the Trusts Act. If you're challenged, if you're looking to justify, if you're looking for an answer, have a look at the Act first. Okay, so Brad said if you fail the reasonable person in business duty, and that duty is referred to in section, is it 22? That's where we've got to look, and that's where you justify your decision, and that's where you look to ask yourself whether you're doing the right thing. Okay, so what other things does a trustee have a duty to do? We talked about duty to invest, to act fairly between beneficiaries of different classes. What other duties do the trustees have? You can quick fire this, unmute your microphone. There's probably 3 or 4 that come to mind. Keep accounts, yes?
22.3 22.3 says trustee must at least once in each year review the performance individually and as a whole of trust investments.
Yes, very good. Excellent. So there's 2. Linda says manage, there's 3. Inform beneficiaries, there's 4. I like all these. What other duties do trustees have?
Is it maintenance?
Maintenance, yeah.
Maintenance and advancement of minors?
Yes, that can be a duty. It can be a power, but it can be a duty as well. Any others?
Insure the trust property?
Yep, very good. Yep. All right. So they're really good examples of what you need to do. And you can sort of summarise these by saying, well, you've got a duty to keep records, to account to the beneficiaries. Strictly, it should be a comprehensive account, report if you like. Why, in theory, is it important to provide a report to beneficiaries? Apart from the fact that it's the beneficiary's money, what's a good legal reason to justify putting that burden on trustees? Comply with
then
that,
you
yeah?
won't be found so that you have informed them, you have keep them informed so that you won't be found in breach of trust, like trying to take profit without informing the beneficiaries.
Yes, so that you're minimising the risk of dispute and potentially court action. That's a really good answer. And if you don't provide that report to beneficiaries, then the beneficiaries won't know, which will either mean one of 2 things. The beneficiaries take action to find out, which means a court action, which is totally unnecessary, or the beneficiaries are stopped from taking action against something they don't like. So if you hide the material from the beneficiaries, if you don't inform them, if you don't account to them in terms of the work that you're doing, then of course it minimises the chance of the beneficiaries going to court to say, we've got to stop this, we don't like that. So it works both ways in a sense. And the courts have said in the case laws, cases that you may have read, that the beneficiaries have something of a duty to bring this to the attention of the courts. You would have read that the courts have said it's not our job to monitor this situation. Someone has to bring it to our attention. It's got to be the beneficiaries. So that ties in with the duty of the trustees to inform the beneficiaries as to what they're doing. Brad says, mitigate the time for disputes due to perceived breach. Yep. And the time is important as well. All right. Now, we said that trustees have an opportunity to engage professional advisors, and stressing the word advisors, we can say that trustees are prohibited from delegating their responsibilities. So what's the difference between a delegation and seeking advice?
I guess ultimately, even when they seek advice, they still have to make that decision, don't they?
Exactly. That's right. And so that's another important point. And the point is that the obligation of the trustee is to, in appropriate circumstances, seek the advice and consider acting on that advice, but they're not obliged to act on that advice. They might be brave if they choose not to act on the advice, but they must at least consider it. And assuming that we've got more than one trustee, let's say we've got 3 trustees, how do the trustees go about dealing with the advice which is provided to them by a professional advisor? What's the practical procedure to adopt?
Wouldn't they discuss it? Do the pros and cons, take a vote?
Absolutely, discuss it, have a vote. Brad says notify the beneficiaries. Grant says pay the money from the trust funds. Justice says Board of Trustees have a meeting and have a vote. I like all these answers. They're all good. And how do we document the final decision of the trustees?
Would you do a report?
A report might be the result of the formal decision, And Brad and Jem are saying minutes. Exactly. I like minutes. That's the answer I was looking for. And the report errand may flow from that minute. But the point is that if you're going to fulfill your duty as a trustee, you must, in appropriate circumstances, which probably means always, document your decisions, and you do that by way of minutes. A bit like a company situation. The other important thing is this, and this is why I said 3 trustees. I said 3 trustees quite intentionally, well, as opposed to 1. I could have said 2 or 4, but I said 3 instead of 1 because there's another principle, another duty imposed on individual trustees. And what is that? The duty to act, I'm looking for one more word.
Honestly.
That flows from
Impartially.
Impartially flows from it. Thanks, Peter. To act without conflict, individually, independently. These are the words I'm getting to. Yep, personally was the word I'm after. But each trustee must turn his or her mind to the particular matter and not delegate. So you can't delegate to outside advisors and you can't delegate to other trustees. So each trustee has an obligation to deal with the issue. It doesn't have to be unanimous, Grant. You can have 2 of 3 vote decisions, so you can have a split vote, but you must make sure that you act in a way that you deal with the issue. Now, of course, that's all subject to the terms of the trustee. Yes, Brad?
John, I put a question there. If the beneficiaries will not provide a decision, trustee may seek direction from the court. So if you're a trustee of a testamentary trust which held an asset in trust and which attaching to that was a life interest to a person, if the trustee wanted to sell that asset, they would then seek a direction from the court if the person with a life interest could not make a decision. So, for example, the house was, say, considered inhabitable for whatever reasons, asbestos, something like that, and the cost to maintain that property or bring it back to a habitual state was considered to be excessive. In that case, is that where a trustee would then maybe go to the court to seek a direction from the court as to of how to then handle that? Because the trustee may consider it to be prudent, but then he would be in breach of other duties as to maintain the life interest.
Look, that's a really good question. That's a really good hypothetical. And a couple of things flow from that. The first is we talked about Howe and Dartmouth and the obligation to be fair between a person with a life interest and a remainder. But in terms of the practical approach, yes, apply to courts. Section 8 of where do we look to see if you've got power to go to a court? Trust Act, Section 8, all right, which is available to trustees and beneficiaries. And also, we haven't got to it yet, but in later reading, we'll talk about the power to make orders that have the effect of changing the terms of the trust if it's expedient to do so. And I forget the section, 85, I think. So that's another specific power which is available to trustees in appropriate circumstances. So to answer your question, Brad, yes, apply to court and get a ruling from the court. Which court do we go to? And where do we find out which court?
Supreme Court.
Supreme Court, yes. And why do we know it's the Supreme Court? Because it's in the
Act.
It's in the Act. Very good. All right. We're all going to have our Trust Act very handy, aren't we? So trustees can't delegate decision-making to other people, not even to themselves. They must act independently of outside people and each other. So they're appointed jointly. They're appointed severally. They're not joint and several. Do you know what the difference is between joint and several and several? Okay, so if you're appointed jointly, it means together. If it's several, it means individually. If you're joint and several, it means it can go either way. Now, we talked, Brad, about trustees having the ability to go to court. I mentioned Section 8. Remember, of course, that Section 8 applies for beneficiaries as well. So a beneficiary can apply to a court to review a decision or a direction or seek a direction in relation to what the trustee is doing. The applicant must show very good reason to a court as to why a decision which is discretionary should be overturned. The case of Re Whitehouse from 1982, Queensland Reports 196, might be relevant in that regard. That was a case that was worked on in an office next to me back in 82, where I was working at the time. So the courts will be reluctant to interfere with the trustee's discretion, but they will consider it, but that you need to show good reason as to why that should be attacked. Okay. Now, question. Can trustees pay themselves for their job? Any thoughts?
No, not unless the trustee says so or the beneficiaries agree to it.
Okay. Erin says no. Sophie says yes. Brad says no. Subject to the trustee. Melissa says yes. So we've got a no, says Ricky, only to enforce reimbursed costs. Okay, so what do we do? Where would be the first place that we look to see what the trustee may do in those circumstances? Bit of a trick question. Sort of. Where's the first place?
Trustee, if the trustee spells it out.
That's it. Go to the trustee first and consider what the trustee says in the context of the law. Where do we first go to look to the law about remuneration for trustees? Trust Act, says Gemma. I could see you saying that with muted. All right, so the Trust Act. What section do we look at for remuneration? It must be further down the Act. We're taking a while to get to it.
I can see 114. I think that's for testamentary trust.
Testamentary. Have a look at 101. So yeah, Brad's got it, 101. So 101 gives the court power to authorise a person to charge remuneration as they see fit. So generally speaking, no, you can't just remunerate yourself. You need permission to do that. And if you don't have specific permission in the trust deed, you'll have to go to court. The discretion is very widely exercised. So I'll give you a couple of cases. Yes, Brad?
John, I put in my answer there, I think I had the deed or the will that established the trust.
Yes, yes.
So if in the will, upon establishment of a testamentary trust, you may then have in there that the trustee is able to charge reasonably professional expenses for the execution of any professional duties.
I agree with that, yes, and you're right. Wills will very often, almost always, set up a trust, and that's why you see so many cases about wills in this subject. Okay, a couple of cases to look at in terms of demonstrating the wide discretion that the courts have. One is Zevering against Callaghan and others. It was 2011 QCA 180. Zevering, Z-E-V-E-R-I-N-G. We're not talking little amounts. In that case, they awarded the trustee $150,000 for doing 1 year's work as trustee. And they said, well, that trustee was a project manager. It was to do with a property development. They did well, so we think, based on the evidence that's presented to us, that the trustee should be entitled to remuneration of $150,000. just bear in mind...
There are a number of factors, I think, the court... sorry, John. I was going to say there were a number of factors that that they look at as to whether they should be paid and how much. And one of them I remember was the difficulty of the trust property that was involved.
Exactly, and the level of expertise involved in that particular case. Absolutely. Thank you, Erin. Close to some of the work I do in the Queensland Civil and Administrative Tribunal is authorising administrators or attorneys to apply in relation to expenditure and remuneration in relation to administration and powers of attorney. All right. Now, on a slightly...
Yes. Could you repeat that?
Yeah, so...
Could you repeat that citation? Zevering or Zevering?
Zevering. Z-E-V-E-R-I-N-G. I hope that's pronunciation.
Yep.
Zevering. V for Victor.
And was it Queensland Reports 180?
2011. Yeah, 2011.
Yep.
QCA 180.
Oh, QCA. Okay.
QCA, Queensland.
And who was the defendant?
Callahan.
Who did you say the defendant? Oh, Callahan.
Yep. So Zevering against Callahan. Okay, so on a slightly different, Grant says page 60 in the book mentions it at 26.137. Thank you, Grant. Excellent. And Peter's got the citation there. All right, so recoupment of expenditure and trying to recoup money from beneficiaries directly in appropriate circumstances. Let's say the trustee can't get the money from the trust deed or from the trust fund. Can the trustee ever go to the beneficiaries and say, I want some expenses reimbursed? And if so, what are the cases? B says yes. Sophie says yes. So
yes, they can, but I don't know the case.
Okay.
Maria Grimthorpe from 1958.
Oh, I must say I don't know that one, Peter. What is it, Grimthorpe? Can you give us the citation on that one? Sorry, I'm not familiar with it.
1958 CH 615 or 1958 1 WLR 381. That's out of the one of those quick reference cards for trusts.
Oh, okay. All right, very good. Or something. Yeah, so that's a Chancery Court. That's an English decision. Look, the one that always sticks in my mind is a very early decision, 1901, Hardoon and Belilios. I don't know. I just remember that case name from the 1970s when I studied. I think I like the ring of it, Hardoon and Belilios. So it established the principle that in addition to proceeding against trust property, a trustee does have a right to proceed against a beneficiary personally for recoupment. Now that can be important if we have a liquidation situation. So the other case that you might want to consider is Octavo Investments against Knight, which is 1979, 144 CLR at 360. Hardoon and Belilios was 1901 AC 118. Okay, so Hardoon and Belilios says you can, as a trustee, you can seek recoupment from beneficiaries personally. Octavo Investments is authority for the fact that in those circumstances, the trustee has security over trust funds that ranks over the interest of beneficiaries, as well as being able to pursue beneficiaries personally. So if you have a situation where the debts are in excess of the amounts of money, then trustees may be able to claim an equitable interest, which provides them security, but their interest will rank above beneficiaries. So before the beneficiaries are entitled to claim their share, the trustee must be reimbursed in relation to proper expenditure and recoupment. Have a look also at section 71 of the Trusts Act, which overtakes a common law position. The common law position was that co-trustees were jointly and severally liable for losses occasioned by the trust. But section 71 says, no, trustees are only accountable for their own acts or neglects or default. So that can be significant as well. All right. So at common law, trustees had, the court rather, had inherent jurisdiction to relieve a trustee from liability. Have a look at section 76, and that comes back to one of the very first things that I said, and that is if you're a trustee and you're under attack and you're trying to justify your position, you would definitely want to have a look at section 76. It supersedes the common law position and it empowers the court to relieve a trustee from liability of a breach of trust if the trustee acted honestly, reasonably, and the court says we should excuse you from that action. Section 77 talks about the trustee's ability to seek advice or obtain directions. And the case law says that if a trustee does that and they obtain an opinion from counsel, then counsel's opinion is a significant matter to be considered by the court as to whether or not to fairly excuse the trustee when seeking to invoke the provisions of section 76 to do so. Did we get all that? It's all interesting, isn't it, really? Any questions? So when you're reading...
Why would anyone want to be a trustee?
Well, it's a bit like that, isn't it? It is a bit like that, I must say. But when you're reading the legislation, when you're reading the case law, try to think of it in terms of a practical application. Put yourself, as you're reading the Trust Act, think, okay, let's assume that I'm a trustee. I'm in business, I'm a trustee. What am I going to do to protect myself? Then think about it from, just for the heck of it, think about it from the other perspective. I'm a beneficiary and I want to attack the trustee or I want to do something. How do I invoke this section or this case law to support my position? Okay.
John, just off that question.
Yes, Erin?
Can I ask, is there an indemnity insurance for trustees who do it as a professional, as a profession?
I would think almost certainly, yes. But I don't know. I don't know for sure. Gemma says, can we repeat the question? Is there an indemnity insurance available to trustees to protect themselves against these circumstances? I suspect so, but I couldn't say exactly. All right. The other thing I wanted to look at was section 80, which gives the power to a court to appoint new trustees. So Brad says Lexon insurance, which is for solicitors. I've got to say, now that I'm a barrister instead of a solicitor, the insurance is so much cheaper. It's wonderful. Anyway, I guess that's all about exposure to risk. Solicitors have trust funds and so many more responsibilities in many ways than barristers, which reflect in their relative insurance payments. We didn't get to talk about this week's questions. I'll tell you this though. If I were you, I would definitely be answering these weekly questions. I'm saying that for two reasons. The first is, it will come as no surprise to you to realise that the exam questions are going to be pretty close to the questions that you've got each week. So if you're answering those questions each week, then you're going a long way to answering the questions that you'll have to do in the exam. The exam is a combination of problem-solving questions, and there's a couple of essay questions in there as well. But mostly it's problem-solving questions. You know, blah, 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 X and Y, set up a trust, etc. This happens, that happens. Yes, I'll go with B first. Sorry, Brad. B?
Yeah, no, sorry, I've been taking your advice, but I don't know whether I'm right or not. And sometimes I get into discussion with other people and we're both equally unsure what we are arguing about.
And B, it's quite possible that you could come to completely different conclusions and I'd still mark you with 7s. That's possible. We say that because, we look at we look at the High Court and the court was split 4-3. Well, both judges on opposite sides might get a 100% mark, even though they came to different conclusions. But we will try and discuss those questions, even if we get to week 12, we'll go through them. But yes, Brad?
With the change of the website and Moodle, it's not easy to find copies of past exams. I can't seem to find a section that says past exams. So I'm assuming there isn't any on there at this point.
No. Look, I've even had trouble. I think I came across a couple, but I'm not sure they'll help greatly. But I'd stick with, I'd answer those questions. The other reason that you want to answer the questions is, and put them on Moodle, and then that becomes your answer. And if I see someone has selected what another student has said and repeated it verbatim, what am I going to expect to see to go with it? I'm going to ask you that you acknowledge that that work was the fellow student's work. You can't just pass it off as your own. I don't mind. Yeah, reference it. I don't mind if you choose to reference it. If you believe that the work of another student is worthy of putting into your exam because it's good and it's accurate and you appropriately reference it, then that's okay. But you probably won't get a lot of marks for originality. You'd want to justify it, and I guess you could you'll be boosting the mark of the person that you've referenced accordingly. Anyway, I would do that. I'd answer the weekly questions, and I would claim my copyright in relation to those, even though you don't say copyright. As soon as you author something, you've got copyright in it. I'm running late for evidence and proof. They'll be on the line waiting for me. So I'd better go. Any quick questions before we leave? All good? All right. Thank you very much. We'll see you next week. All the best. Bye.